Get out! I want you out of my house right now!
Please stop yelling at me. I don't know what to do.
I signed the final divorce decree with a $3 ballpoint pen from the courthouse gift shop, while Derek signed his copy with the fountain pen his new fiancée had given him for his 41st birthday. He got the house, the company, and 78% of our joint investment accounts. I got a modest settlement, alternating custody of our 2 kids, and one thing his legal team never once thought to ask about. Enjoy the company, I told him in the hallway afterward. Just remember whose name is actually on the patent. He laughed. He wouldn't be laughing 11 weeks later. I'm Emily Foster, 38, a chemical engineer with a doctorate from a program I finished 12 years ago, specializing in polymer-based anti-corrosion coatings. I met Derek Sinclair during my final year of graduate research when he was raising seed capital for a materials startup and needed someone who actually understood the chemistry he was pitching investors on. We founded Sinclair Coatings together 9 years ago, though together turned out to be doing a lot of work in that sentence. Derek incorporated the company as a single-member LLC under his name alone, explaining at the time that it simplified early tax filings, a decision I agreed to without fully understanding what it would eventually cost me. The company's flagship product, an industrial anti-corrosion coating used in bridge infrastructure and marine equipment, was built entirely around a formulation I developed during my postdoctoral research, refined over 3 years of trial batches in our garage before the company had a single paying client. Derek sold it. I made it work. Our marriage began fraying roughly 4 years into the company's growth, once Sinclair Coatings started generating $8 million in annual revenue, and Derek began describing the business almost exclusively in the first-person singular during investor calls I was sitting in the room for. I filed for divorce 14 months ago, after discovering a pattern of financial decisions made entirely without my knowledge, including a $400,000 company loan he'd personally guaranteed against assets I'd assumed were jointly held. Derek hired Whitcomb and Associates, a firm known for aggressive asset structuring and high-net-worth divorces, 6 weeks before he ever mentioned the word divorce to me directly. By the time I retained my own attorney, Derek's team had already produced documentation positioning the company as his separate property, built on the LLC structure from 9 years earlier that I'd signed off on without appreciating its long-term consequences. The court, working from documentation showing sole LLC ownership and years of Derek's public role as CEO, awarded him the company, our $1.4 million house, and the bulk of our investment portfolio, valuing my consulting contributions at a fraction of what I'd actually built. I walked away with $180,000, our minivan, and joint custody of Maya, 9, and Ben, 6. What none of Derek's attorneys thought to verify was the actual assignment status of U.S. patent, 10,847,229, covering the coating's core formulation, filed 6 years earlier listing me, correctly under federal law, as sole inventor. Patent assignments to a company require a separate signed transfer document. Ours had been drafted during a cash-strapped stretch of the company's second year, and, due to an administrative oversight neither of us caught at the time, was never actually executed. I didn't hide the patent from the court. It was listed as a company asset in Derek's own disclosures, described by his attorneys as fully assigned. I simply never corrected their assumption during proceedings, a decision my own attorney, uneasy but professionally cautious, described only as not our obligation to do their diligence for them. 3 weeks after the divorce finalized, Derek's head of production, a chemist named Raj Patel, I trained myself 5 years earlier, called me, against explicit company policy, he admitted nervously, asking whether I'd changed the catalyst ratio in the formulation notebook before I left. I hadn't changed anything. I'd simply taken my personal lab notebooks, the ones containing details never formally transferred to any company document, when I moved out. Certain elements of the formulation, specifically the precise temperature stage curing sequence and a minor catalyst substitution I developed informally to reduce production costs, existed only in my own notebooks and memory, a common practice among research chemists protecting proprietary process knowledge even within their own companies. Derek's team had the base formula. They didn't have the part that made it consistently manufacturable at scale. Sinclair Coatings was 11 days from delivering the first shipment of a $4.2 million State Department of Transportation contract for bridge deck coating, the company's largest order to date. Production batches that week began failing standard salt spray corrosion resistance testing, a critical specification the contract required documented compliance on before delivery. Raj and two other chemists spent 9 days trying to reverse engineer the inconsistency, adjusting variables that had nothing to do with the actual problem, because the actual problem lived in a notebook sitting in a box in my new apartment's hallway closet. Derek, increasingly frantic, called me directly for the first time since the divorce, asking without quite asking whether I'd be willing to consult. I told him the truth plainly. I wasn't willing to consult for free, and given how the divorce proceedings had characterized my role, I wasn't sure what legal standing he thought he had to ask. His trembling voice, for the first time in 9 years of knowing him, carried something other than confidence. Emily, I need this contract. I have loans personally guaranteed against the house. Facing contract default penalties, Derek's legal team finally pulled the actual patent assignment paperwork and found what I'd known for months. No executed transfer existed. The patent, and by extension enforceable control over the exact formulation protected under it, remained legally mine. Sinclair Coatings missed the DOT delivery deadline. The contract included a liquidated damages clause triggering $620,000 in penalties, and the state agency, citing the quality failures, terminated the remaining $3.6 million of the contract outright, citing documented non-compliance across 3 consecutive test batches. News of the terminated contract reached Sinclair Coatings' 2 other major clients within 8 days, both of whom paused pending orders, citing quality assurance concerns. Company revenue projections for the quarter dropped 64%, triggering a covenant default on the very loan Derek had personally guaranteed against our former house. Derek called a final time 19 days after our divorce finalized, no longer negotiating from confidence. He offered me a licensing arrangement, a formal consulting role, even partial equity restoration, terms that 11 weeks earlier, during our marriage, I'd have accepted gratefully. I asked for 48 hours to think it over, mostly because I needed to make sure my answer came from clarity, not vindication. I didn't take his offer. Instead, working with an intellectual property attorney, I licensed the patent to a competing coatings manufacturer, Alden Materials, for an upfront payment of $1.1 million in ongoing royalties, structured specifically to include hiring provisions for any Sinclair Coatings employee who wanted to transfer, and offer 6 of Sinclair's 11 technical staff, including Raj, accepted within a month. Derek's company filed for Chapter 11 bankruptcy protection 4 months after the divorce finalized, unable to secure a comparable replacement formulation or refinance the defaulted loan. The house was sold in the proceedings, the same house awarded to him in our settlement, to satisfy creditor claims. I used the licensing payment, alongside a small business loan, to found Foster Materials Consulting, an independent formulation lab supporting 3 coating manufacturers, including Alden, now generating $1.6 million in annual revenue within its first 14 months. Modest compared to Sinclair Coatings' former scale, but entirely verifiably mine. I didn't explain the full legal details to my kids, but Maya, now 10, asked me directly one evening why Dad's company wasn't around anymore. I told her the truth in a version she could hold on to, that sometimes the credit for building something doesn't automatically go to the person whose name is on the door, and that it matters, eventually, to make sure the truth catches up. I've since started informally mentoring 3 other women in technical co-founder roles, walking them through the specific paperwork, assignment agreements, inventorship documentation, equity structuring that I never fully understood mattered until. It was almost too late to matter for me. A National Association of Women Inventors estimates that female technical co-founders retain full IP credit in only roughly 1/3 of startup ownership disputes reviewed in recent surveyed cases, a statistic that stopped feeling abstract the day I read it. Derek took the house, the title, and 9 years of public credit for work that was never entirely his. What he couldn't take, because it was never his to take in the first place, was the actual knowledge living in my own hands and notebooks, proof that ownership on paper and the ability to actually build something are not always held by the same person. The lesson isn't that I got even. It's that the things people take from you in a divorce, a lawsuit, or a boardroom are rarely the things that actually made you valuable to begin with. And sometimes the only justice available is simply refusing to hand over the one part they never really understood how to ask for.